Let's see, do we have everyone here? Looks like we do. This is the case of Ragsdale v. Fishler. We welcome everyone to our virtual Supreme Court. As you can see, we're joined by Judge Diana Hagan. We are very pleased to have her sit in Justice Himones's stead. Justice Himones has recused himself from this. Just a few thoughts about this virtual experience. We're old hands now. This is our fourth case, but I know for counsel this is brand new. We may have technical glitches. Don't worry about it. We expect that will happen. It could happen on your end or our end. If so, we'll just take the time necessary to remedy it. It's a little bit of a challenge in terms of knowing how to indicate our desire to answer a question. So in some cases, a justice may raise his or her hand. That's more a signal to the other justices that they would like to go next. If a hand is raised, you should endeavor to conclude your sentence as quickly as possible to get to the question. In some cases, a justice may not raise his or her hand. That's fine as well. But one way or another, we want to ensure that all the questions get asked. We see this really as an opportunity for us to educate ourselves. And for that same reason, if we have questions or continuing to ask them when your time expires, don't worry about it. It does not cut into any reply time, and it is perfectly appropriate for you to continue to respond to questions without asking leave of court to do so. So, with that introduction, let's turn to our argument. Counsel, please enter your appearances.
Yes, James Dunkelberger of the law firm of Bennett, Tueller, Johnson, and Deer for appellant Christy Ragsdale.
Welcome, Mr. Dunkelberger.
Thank you.
Karthik Nadesan on behalf of appellee and cross-appellant George Fishler.
Good to have you here, Mr. Nadesan. Okay, let's start.
Yes, thank you. So James Dunkelberger again for appellant Christy Ragsdale. May it please the court. This court should reverse the district court's decision, which attempted through a number of legal conclusions to carve out broad swaths of conduct and speech from the stalking statute. And we'll refer to the stalking statute a number of times, but that's that criminal statute 775106.5. Nowhere is that seen, I think, more clearly than in the conclusion of law number 4. And this is at page 54 of the record, quote, "In this day and age, exposure to pejorative gestures and profanity should not cause the type of significant mental or emotional distress envisioned by the statute. The court therefore concludes that Ragsdale has failed to establish that a reasonable person under the same circumstances as Ragsdale would have suffered emotional distress," close quote. So as the district court saw it, that is the law of the state of Utah. The thing that's problematic about that is that it contravenes this court's decision in Baird v. Baird. There's no carve out for profanity or for any other type of conduct, and it refers back to the plain language of the statute, which is very broad and meant to encompass a very broad range of conduct that may amount to stalking, including speech. Again, communicating to a specific person, directing that communication at them. Baird rejected the earlier Lopez standard of extreme and outrageous conduct, which focused on the conduct itself or the content of the speech. There, the Baird court specifically said, quote, "While the Lopez emotional distress standard focuses on the severity of respondent's conduct, the statutory definition of emotional distress looks solely at the nature of claimant's injury," close quote. And that's really what we're suggesting here, is that by making that threshold determination that pejorative gestures cannot amount to stalking, it's a carve out which is not supported by the language of the statute and not supported by Baird, where it referred to the example that even innocuous conduct, such as sending flowers or anything else, could amount to stalking when taken in the context of the rest of the course of conduct. A similar issue occurred with respect to the political speech, and that's why that's problematic. It's not necessarily even getting to the First Amendment issue. Before we even get there, the court should look at what it means to the definition of course of conduct if a large swath of conduct that's deemed political, or in this case even that is just maybe politically neutral but driven by a political animus, is accepted from the definition of a course of conduct. And it's problematic for the same reason as the other. Yes, Your Honor.
Yeah, I think you raise a number of really good arguments in your brief, but one point of concern for me is just what does the factual record look like with respect to conduct that would cause a reasonable person to fear? And what I specifically mean is what evidence is in the record is there about proximity? Did the record reflect that these were coming, solely from the driveway as people were going by, and so nobody could reasonably fear because they were driving by? Well, what's the best evidence that this behavior would cause a reasonable person to fear?
Sure. So I think that there was conflicting evidence in the record with respect to proximity. You'll see around, I think it's R188 through R200 is where we're talking to Mr. Fishler himself about the conduct. And there's some dispute in there with respect to where he is. On cross-examination, he acknowledged that he may not be standing solely on his driveway. And so there was a little bit of a dispute about that. You saw evidence that we presented or elicited that there was accosting, shouting, waving arms, purposely driving by, other things. But it's unclear from the record whether that was credited.
Can I ask you about accosting? It's not clear to me what that means in the context of this factual record. What does the record actually show with respect to the behavior that you're throwing into that accosting category?
Sure, and I think here we actually need to look no further than the actual findings that the district court made. You've got those last three findings of fact number 6, 7, and 8, which go to this prong, which is basically the directed at. And the fact that was actually found was whenever Fishler saw anyone who appeared to be an employee, student, or otherwise associated with ECA, he would raise his middle finger in a pejorative gesture and mouth or say profanities. Now, in later findings, he said, the district court said that was directed towards anyone that he believed to be associated with ECA, including Miss Ragsdale. So even though there was conflicting evidence on the subject of accosting or proximity or other things, that's the finding we have, this long course of conduct. Yes, sir.
But we don't, Mr. Duckelberger, you don't represent any of these other people, right? You don't represent the entity. You represent Ms. Ragsdale. So part of the problem that I'm having, I think you may be right on this threshold point in terms of the standard that the district court applied. That seems problematic to say what the district court said there. And I think it sort of gives rise to this weird sort of, well, you have a defense as long as you're directing activity at a whole bunch of different people. That seems like that can't be right. But that it seems to me that then polluted everything else that the district court did. I don't know what to make of the ultimate mixed determination that was made with respect to, what a reasonable person in these circumstances have suffered emotional distress. So in response to Justice Pierce, you're pointing to things that were said to other people other than Ms. Ragsdale. We don't have any differentiation in the district court's analysis as to what specifically was said to your client. And I don't know what to do with that other than, do we need to remand?
I think it's just to stay very closely to the findings that she made.
But that's my problem. How do we do that? Because there aren't findings about specific things that were said to Ms. Ragsdale. And I think the theory of your case would suggest that that's what she should have done.
Yeah, that's certainly right. I mean, on the findings that we have, it's difficult to see where she got. And so we're kind of, in a sense, stuck with that in her oral ruling, which doesn't give us much more clue. But there's two things, I guess, that her ruling kind of and her findings do sort of give us. It's that we have almost kind of buckets of conduct, right? We have a bucket of conduct that does seem to be directed at Miss Ragsdale, and that's supported just by finding 7 towards anyone, including Ragsdale. So we have this conduct that is indisputably directed towards Ragsdale, excuse me. And then you have this other conduct that may be to other people. Maybe that's where, on the finding of fact that it was indirectly targeted or directed at Ragsdale through her coworkers, maybe that's a separate issue because it's a separate bucket of conduct. But here it's undisputed. And I think the district court found that there was a course of conduct directed specifically at Ragsdale that's supported elsewhere in the record. And that's really all we need. The court needs.
How do we know? I mean, it seems like maybe there were at least a couple of instances in which things were said, or the middle finger was extended to your client. But I don't have a feel for how often that happened, under what circumstances that happened, and all of those things are relevant to me, and I think important to making the ultimate mixed determination under the appropriate standard as to whether this rises to that level of severity of significant emotional distress.
Certainly.
And I don't know how to sort that out.
Yeah, if that Baird analysis had extended to those factors, right? If you would have seen the ruling or the findings of fact and conclusions of law go to those specific points, the cumulative effect, or even if the conduct was part of that Baird analysis, the severity of the conduct, we're not saying is necessarily irrelevant to whether a reasonable person would suffer emotional distress. But what you can't do is go back and carve that out and say, we're not looking at this whole group of conduct because just as a matter of law, it wouldn't equal emotional distress. And so what you're left with is kind of to grapple with the district court's failure, and that's part of the problem, to really analyze that and to make specific findings with respect to the severity of the conduct. So for example, at record 105,
before you answer that, and this might help in responding, as I've reviewed the transcript of the hearing, it does seem confusing, at least to me somewhat, as to how many times Ragsdale herself experienced this conduct. Sometimes it's suggested it might have been quite a few times. Sometimes it's suggested, I think, that it might have even been as few as a couple of times. And maybe you can help guide me through this. And even apart from the findings the judge made, which I agree with Justice Lee's description in that respect, what record of evidence is there that she, as to the kind of Baird factors that you're arguing that the court should have applied in terms of, how long, under what circumstances, and so forth?
Certainly. So I'll just direct the court to R103, which is kind of for discussion about that. And that's where we pull from our statement of facts dozens and dozens. And where that spans those years. There, if you look at lines 6 through 11, for example, but personally, you've had personal interactions with Mr. Fishler. Yes, many interactions, I would say dozens and dozens. And so even if that is later disputed, without findings of fact or an analysis under Baird of whether or what that course of conduct would do to affect a reasonable person in Miss Ragsdale's circumstances.
Can I jump in before you finish this thought? I want to make sure I understand something. Was the testimony that there were dozens and dozens of interactions, or dozens and dozens of interactions involving the kind of language and behavior that you're complaining about here?
The latter. So there was testimony that there never was a positive interaction. And I think Mr. Fishler even elsewhere, and the district court credited this, and whether it was an admission or what, but acknowledges that it's always this sort of coarse language and name calling, pejorative name calling in each of these interactions.
But my understanding is that your argument was that the interactions with the other coworkers were relevant as well because they were directed at Mrs. Ragsdale in order to upset her and harass her. So are you arguing that only those interactions directly with her should be part of the consideration, or that all of the interactions were ultimately targeted towards her?
Yeah, well, we argued and presented evidence on both, right? And that finds support in the statute where there's sort of multiple paths to where you want. So again, with that first bucket of conduct, the direct interactions, when it was just Mr. Fishler and Miss Ragsdale, that's one. But then also the statute, you can indirectly stalk somebody else through the coworkers. And so if we had been able to, as a matter of fact, demonstrate that that's what had happened, that would have been another way to do that. Now,
but the district court ruled against you on that, right?
That's right.
This goes to this threshold point. I think the district judge was probably wrong in making the ruling as sweeping as it was made, to say that there can never be any stalking claim, because the stalking went to all of these people. I mean, that doesn't seem like that can be right. But to the extent what the judge was saying was, no, I do not find that in directing acts at other employees of the entity, that those were indirect attempts to get at Ms. Ragsdale. I don't see that that's wrong, or that we're in a position to reverse that.
Yeah, that's right. And candidly, with respect to that specific prong, I think if you look at the relief that we sought in the injunction, it actually probably doesn't go that broad, right? I mean, it doesn't go to, you cannot contact anybody at the home, even if you see them somewhere else besides coming or going from Eva Karsten Academy, because we now have this stalking injunction in place. It doesn't, the injunction itself wasn't probably broad enough to do that. And so in our view, there really wasn't a reason for her to deny it in toto because of this idea that we couldn't establish factually indirect stalking. Yes, Your Honor.
But let's talk about that first issue, because if we find that the court was correct, that this conduct wasn't directed at a specific person, we don't need to reach the other issues, is my understanding. So how can we say that the district court was incorrect in saying that it wasn't directed at a specific person when there was testimony to support the idea that, well, and a finding that this was done whenever Fishler saw anyone who appeared to be an employee, student, or otherwise associated with ECA, that this really wasn't about Mrs. Ragsdale at all. And the statute does require that the conduct be directed at a specific person. So what is the error in the district court's findings in that regard?
Sure. The difference is between the objective and the subjective. So if I'm alone with Miss Ragsdale in the street, okay, and my objective conduct is I am saying F you to her and calling her a name. Okay, that is directed to her objectively. That's the course of conduct. It doesn't matter if I have a subjective intent to secretly or not so secretly protest the business. Just as if I had a problem with what Starbucks was doing, I don't like that they changed the color of their cups, right? I'm going to go protest through the manager of a Starbucks, right? I'm alone with the manager, but my secret intent is I really only have a beef with Starbucks, right? That doesn't work. Now, if I can't establish factually indirect stalking through the coworkers, that's a different bucket of conduct. But where the district court went awry here is to require that second, not just to prove a course of conduct, because she credited that it was directed towards anyone, including Ragsdale. She found, as a matter of fact, there was conduct directed at Ragsdale, but then requiring that we also disprove that there was some other subjective goal in mind. And the statute.
We can back on that just a tiny bit. So what if Mr. Fishler was upset with the courts and stood out on the front steps of the Matheson courthouse and mouthed or said profanities and raised his middle finger at everyone who walked out of the courthouse doors? Could that establish stalking? Is that conduct directed at a specific person?
Well, I think there it's distinguishable from what we have here based on whether it is directed as a specific person. If you stand on a stage or if you stand out in front of a step where you see and you're addressing everybody at once, that's one thing. But when you're directing conduct specifically at somebody when you're alone, that's a little bit different. So in your hypothetical, again, to bring it within the facts of this case, the hubbub over your ruling has died down. Okay, we're 2 weeks later, right? The clamor, the picketing, the letter writing campaign, contact your senators, don't retain these guys, all that's over. And now we just have every day coming to and from work, it's FU and pejorative name calling. And there's no argument that it's directed at anybody else but you because there's nobody else on the street but you. And so that's the difference. Now, maybe they're doing that to the other justices at the same time, going to each of their houses and doing that individually. But are you really going to let them say that that's not stalking just because, oh, well, you know, I don't have a problem with Justice Lee. I don't have a problem with Justice Pierce or anybody else. I just have a problem with the court. I just have a problem with the ruling for 2 or 3 years when it's directed just at the person.
But there is a difference, right? This was not her home. This was her place of business. And he was, it sounds like undisputedly on his property in a place that he was entitled to be. Does that make it a different? I mean, does that make it more like standing on the steps of the courthouse or outside an abortion clinic or outside, you know, anything else that one might be protesting? Does that make it more similar to that type of situation?
Maybe, but that's exactly why you have to analyze it in light of those other factors that Baird listed or the other factors that might be relevant given the specific facts of a case. I mean, that's exactly why you can't just take it back then to the definition of course of conduct and say, well, hey, it's political speech, or hey, it's just name calling. It can't ever be a course of conduct. You've got to run it through the rest of the facts. So here, basically, if there's two elements, and if you look at it this way, I've got to establish a course of conduct, and then I've got to establish that it would have this certain affect on a reasonable person in the victim's circumstances. We've got the first one here. Okay, she already found that it's directed at Miss Ragsdale. Okay, what she should have done then is taken it back to Baird and said, okay, but you know, it's a circumstance. He's upset. There's a specific reason. He does have a political animus. All of that might be relevant at the Baird step, but you can't use that as a statutory carve out. That's why it's an error of law to take it back and say that can never be a course of conduct that could ever amount to stalking.
Would you agree with this statement? To me, it seems that your argument is, even if it's political speech, and it could be argued zoning can get very political, right? Sometimes more than anything else. So he feels strongly about a business being located in his neighborhood. Let's say that's political. He can protest that, but not through behavior that rises to the level of stalking toward an individual person. And it might rise to that level with 10 people or 15 people. But if with regard to one person, it reminds me of, you know, early in the 2000s, late 1990s, when when PETA would put pies in the face of CEOs of companies that did animal testing. Now, a pie in the face might be some sort of assault, so that may not work here. But let's say that was clearly not about the individual CEO. It was about a company doing animal testing. Let's say that the way that they protested that, not something that physically touched the person, but was to go around and show up in public areas every time that person was walking into a building for a meeting, giving a speech, maybe even out on the public street every night in front of their house, calling that person names. We might say, you know, is there a line between that political message is absolutely appropriate, but is there a way that if you express it in a way that meets the definition of stalking with regard to a particular person, it's not protected anymore. That conduct's not protected. You can protest this as much as you want, but you can't do it in a way that equals stalking of a person.
Yeah, that's exactly right. And Baird and Towner, the Towner v. Ridgway case, that's your roadmap there. because that's exactly what Towner said. So in Towner, and Baird demonstrates this too, it essentially establishes that course of conduct is essentially conduct neutral, or it's content neutral, excuse me. Because in Towner, right, he's going to these conventions, right, and he's saying, you're a backstabber. You said you were going to support me, and then I didn't get the votes, and then this and that and that. And he's going up and he's calling names, but it's names about, hey, you didn't support me, or you're a liar, or this and that and the other thing. I mean, it's much closer to political speech just on its face than what we have here. I mean, not saying that profanity couldn't be political speech, but yes, Your Honor.
Yeah, so that leads me to a question that I had. You know, in Towner, we did touch on the constitutional issue, but didn't engage in much of an analysis there. It wasn't necessary. And that's one of the things I find challenging about this case, is how to sort through the constitutional issues. Now, you've suggested in your briefing that, well, that could be a factor. But it's not crystal clear to me, and Mr. Nadeson will be able to address this. Perhaps you can tell me how you perceive it and how you would argue against it. It's not crystal clear to me precisely what the constitutional challenge is. It seems to be a kind of as-applied challenge. And it seems like that any political motivation certainly would have to be a factor in some respect. But how do we sort through the fact that clearly the Stalking statute on its face prescribes speech, communication, and really amounts to a prior restraint in many instances? So how do we, or walk me through how you think the constitutional analysis should proceed?
Yeah, sure. And there I just refer it back to Lopez. So Lopez has been superseded by statute, and the Baird court discusses Lopez. But that's the case that we have really in Utah that attempts to resolve that frontier, if you will, between the Stalking statute and the First Amendment. And basically what it finds is, or what it held in that case, is that the Stalking statute does not prescribe large amounts of protected conduct. You've got to fall under the definition of stalking to get there. But just like in Chaplinsky or many other exceptions that we have, exceptions are made not only for fighting words and obscenity, but for things like stalking. And so one way to conceptualize the Stalking statute.
Sorry, are you arguing? It's not clear to me that you're arguing that the established exception of conduct or speech integral to a criminal act has application. Or are you? Or are you arguing it's a separate kind of accepted First Amendment conduct?
I think basically what we're saying, and we're not going too far when we say that the Stalking statute is essentially a codification of an existing exception to First Amendment protection. Okay, basically, if you can meet this definition of stalking, we have all kinds of categorical exceptions, and there's complicated tests for how to get there, right? Take obscenity, or, I mean, fighting words, who knows, right? But I mean,
what is the established exception? Pre-Stalking statute, how would you describe it?
Yeah, so Chaplinsky kind of gives the list, but language that is threatening, annoying, otherwise harassment, right? You see cases that will say, oh, there's an exception for threatening or harassing.
Well, there can't be an exception for annoying, right? There can't be an exception for annoying.
Well, and again, if it's just annoying, it's not going to fall under stalking, or falling under stalking as in our Stalking statute. So we don't really have to worry about that. But when these cases say there's an exception for threatening, et cetera, this is nothing more than the way that you get there. You establish that through.
Take out threatening, okay? Because I think your best argument is not one that she felt her safety was threatened, but rather she suffered emotional distress. So I'm interested in the pre-Stalking statute exception for conduct going to, resulting in emotional distress. Can't be just annoyance, not threatening in this case. So how would you describe that exception?
Yeah, harassment, disorderly conduct, disturbing the peace, etc. And what you really see there is Lopez kind of seizing on the language of the stalking statute and kind of making that argument. I mean, not in exactly the precise way, because in Lopez it was freedom of movement and freedom of association, but there's no reason that you couldn't extrapolate Lopez back into, okay, yeah, there's speech. The statute on its face is going to cut out some or is going to prescribe some speech, me to a tenant that I'm not getting along with, or me in a contentious situation, but it's not going to offend the First Amendment as long as you can fall under those other elements. And that's why you've got to have that political speech component as part of the overall Baird analysis, right? And you've got to be careful on the back end as well, that the injunction doesn't proscribe too much speech that's otherwise innocuous. So, for example, and Towner makes this clear, if the injunction had said, Mr. Ridgway can never go to a political convention in Utah again, because it's ugly. Obviously, right? That's problematic. If we had asked, Mr. Fishler can never write a letter to his state legislator about Eva Carlston Academy, right? Problematic, right? Why? It's because at that point, right, it's potentially overbroad and other things, and you get back on the back end to where that's problematic, even if you have otherwise established what you might constitute stalking.
In that respect, wouldn't the analysis of the signs be different from the analysis of the, raised middle finger and mouthed obscenities?
So the signs are in a different bucket. So we talked before about buckets. One is, and I think this is the easiest, right? F you, you little B word, right? When it's just me and you on the street, or when, as the district court put it, it's directed towards Ragsdale, okay? Then there's the coworkers. The signs are another bucket, if you will, of communications too. But even here, we have an admission, and you can see this even in Mr. Fishler's brief. He put the signs there not to reach the public at large. In fact, he said he didn't want to reach the public at large because he didn't want to draw undue attention to himself and bug his neighbors. He wanted the people, including Ragsdale, going and coming from ECA to see the signs. Now, the signs by themselves, again, running it through that Baird analysis might not be enough, but when you take it as part of the course of conduct, and you can't exclude the signs from the course of conduct, our appellate cases in Utah make that clear. You've got to consider, even though these buckets might be separate, you've got to consider the different types of speech and the different ways that the person is engaged in this course of conduct together as a course of conduct. Now that we have the rest of it, you back into the signs where, yes, as part of an overall course of conduct, those signs now mean something different than had they just been there in the first instance, or had he taken out another sign somewhere else, or had he written to a congressperson or started a letter writing campaign that that Miss Ragsdale felt besmirched the business or other things. Those are all, you back into the signs after you have as well the FU and the name calling and the other things for so long. And that's why the signs are fairly enjoined under this injunction, because it's not just that they say what they say, but as part of this overall course of conduct, they do or would cause somebody emotional distress. And we've got case law that talks about reminders. This is a reminder that the person is there. Okay, this is a way of communicating to someone, and Mr. Fishler even admitted that that's what it was meant to do in this case. So again, and that's why it's so crucial that we can't just take and say, again, the three areas of law here. We can't say pejorative speech or political speech is not part of the course of conduct. And similarly, we can't say because you're stalking everybody, you can't be stalking anybody. You've got to take the course of conduct, which you already found, and then you've got to run it through that second set of factors, and that's the error.
I have one question about the court's factual findings. The court, of course, found that he did the signs, also talked about mouthing the profanity and making the pejorative gestures. do we take from that that the court implicitly did not credit the testimony about him, for instance, spitting at people, waving his arms, doing the other things that your client accused him of? Do we read the court's findings as that this is the extent of his behavior that would constitute a course of conduct?
Yeah, and her oral ruling is actually helpful on that because she gives a little bit more about that. She did not credit, I guess, spitting on or at somebody as part of the course of conduct. There was testimony about a pelvic thrust or something else. She did not credit that as part of the course of conduct. And again, those factual determinations are one thing, but the fact is we have an undisputed course of conduct that falls within the ambit of the statute. Done. That's all the more you need to do on that element. Don't require us to prove another element, but then jump right back into your Baird analysis and go from there.
Thank you.
Any further questions at this time?
Looks like not. Thank you, Mr. Dunkelberger. We'll now turn to Mr. Nadeson.
May it please the court. I apologize. I'm used to thinking on my feet, so it's going to be difficult for me to think while I'm sitting down. This is a sort of unusual case in the sense that this is not the normal stalking case. This is not the ex-boyfriend, the harassing boss or employee, the traffic accident by someone who follows over. This is someone protesting a commercial business next door. And the response from the commercial business after 4 years, and after sending letters, cease and desist letters saying you're interfering with our business, the response is to file a stalking injunction claiming that Mr. Fishler is stalking the owner of the business. And this goes to sort of the directing and the course of conduct issue, which is the statute requires it has to be directed at a specific person. And specific person, obviously person also includes corporations and entities. That's just the law of the land. Now, the reason why I think the court brought out that one interpretation of the judge's ruling is that if you stalk everyone, if you engage in a course of conduct with everyone, then you can't do it against a specific person. I don't think that's the correct interpretation. I think the correct interpretation is what is the ultimate goal? What is the ultimate target of this behavior? Is this behavior targeted at a particular individual? Is it targeted at an entity, a corporation? Who is it targeted at? Because I think that's part and parcel of that statute. It requires direction not only for the course of conduct. It says the course of conduct is 2 or more acts directed.
Can I ask you about that though, Mr. Nadeson? I mean, it could be directed at both, right? It could be sort of ultimately directed at the entity, but literally directed at Ms. Ragsdale in some limited instances, and it seems like it's both here.
Yes and no. I mean, the actual physical act is observed by Miss Ragsdale, and it's given to her, but it's not directed at her in the sense that this is the ultimate target of my actions. My ultimate target of my actions is I would like to tell Miss Ragsdale how I feel about her. That's not what is going on here. And I think we have to look at the statute, which also requires an intentional.
How do you deal with the hypothetical in Mr. Dunkelberger's brief about, well, somebody can harass all 5 members of the Supreme Court and say, hey, it wasn't personal to any of those 5 people. I was just angry at the Supreme Court, and they can harass us every single day, all day long as that's the explanation. I mean, don't you run into that problem?
I think we have to separate the word harassment and conduct directed towards the Supreme Court. So if, for instance, every time, I think the example was the Supreme Court walks out of the courtroom doors, there's a protester out there, and he says a curse at them, or he gives them the finger. Is that directed towards those particular individuals? Is that a course of conduct directed towards them? Or is it a course of conduct directed towards the entire justice system or the Supreme Court itself? Would a Supreme Court justice be able to come, sorry, Justice Pierce?
That's okay. Let me give you this hypothetical. So let's say that every time I go to the grocery store, somebody comes up to me and says, I got nothing against you, but I hate the court. And I think at some point the court needs to go, right? Something bad's going to happen to the court, but I got no problem with you. But it happens again and again and again. And I can establish that puts me in fear, and I can convince somebody that would put a reasonable person in fear. Is it really a defense to that conduct that he says, well, I'm not directing it towards Justice Pierce, I'm directing it towards the court as an institution?
No, because I think that's a hard comparison, because the argument isn't here, obviously, right, that this person is following you to a grocery store, that Mr. Fishler is following someone to a grocery store or doing any of those. He's actually equal opportunity. So I guess the example would be the person is at the grocery store, and every time a Supreme Court justice walks into that particular grocery store, because he's not following them, he says, I have no objection to you, but, and then he says a curse. He doesn't say a threatening word. He doesn't say you have to go, which is another element.
Yeah, can I stop you there, though? But that seems to be conflating two things, which is the conduct that would cause somebody to reasonably fear and directing, right? And so I think you may have a pretty strong argument on there wasn't evidence that Mr. Ragsdale engaged in conduct that would cause somebody to reasonably fear. But I don't think it's helpful to conflate that with the directing.
Right, because you're right there. I mean, there are two different elements. I think that's correct. But I think that when we look at directing, we have to be really careful about the circumstances where it's occurring, because I think the circumstances of who it's being given to, how, and whether it's universal, whether it's directed at a particular person is important. I think once you start saying that this person is approaching you at a grocery store, it becomes more he's directing this at you, versus this person is outside of a courtroom where he's not in control of who goes by or who doesn't go by, and he says it to everyone universally as they go by. I think that changes what directing is. And I think another important point to look at is what was argued in front of the district court. Because when we talk about the district court, the argument there was not, hey, let's look at just the interaction with Miss Ragsdale, and then maybe there's also these other indirect interactions we think were also targeted at Miss Ragsdale. Instead, the argument to the district court was, you have to look at all of these as being directed at everything. The ultimate target of all of Mr. Fishler's actions was Miss Ragsdale. It wasn't Mr. Fishler was protesting ECA, and Miss Ragsdale was collateral damage and was exposed to this, and she doesn't really like this being exposed to this, so we consider it stalking. Sorry, Justice Duran.
Take this hypothetical. Someone never leaves his property, but he believes that society has degenerated. It's the fault of one party or another. And that part of that moral decline can be seen in the way women dress, maybe short skirts. He sits out on his porch, and let's say there's one woman, she lives in the same area. Every time she walks by, he flips her the bird and mouths with profanity. And so just one woman. And he does this repeatedly over a course of 4 years. You would acknowledge, would you not, that falls fairly within the stalking statute,
Yes.
Notwithstanding that he has a subjective political motive?
Correct. I think but I think that's important to distinguish as subjective and objective. So I can say my intention was to attack this, and here again, we don't have a specific person, right? His excuse is, I'm attacking society's, I guess, morality in general. But that's not what we're looking at here, right? That's why it's a hypothetical.
Okay, so, and his motive is pure, not a pretext in any sense. It's a genuine political protest. Okay, so one woman, he does that to one woman, stalking. Now, let's say there are 3 women who live nearby.
Right.
He does the same thing to all 3 of them over a course of 4 years. Okay, now he has a defense. Wait a minute. Not directed at one person. It's multiple people. And my ultimate objective is a political one. It's a political protest.
Well, and I guess let me clarify here. So in your example, there is no target beyond, there's no direction beyond that, because you can't just say I'm targeting society's morale. That's not a specific person. And the statute requires it has to be directed at a specific person. here, if the argument, I guess the argument is a different.
Okay, that's good. Let's say the mayor is one of the people he holds responsible for this. And so it's resulted in a degenerate citizenry. So he wants to get that to the mayor. He hopes these people will report it. And so that's his point. Does he have a defense now because he has a person in mind, a mayor? He has a purely political objective, and there are multiple people he is targeting. So is that legitimate then? Not violative?
I think at that point it becomes a question of fact, where the court is going to look at it objectively and say, who is the ultimate target of this conduct? Was the ultimate target of this, was it the mayor, and he was trying to indirectly communicate with the mayor through these individuals?
Well, why not two targets? I read the statute. I'm not sure where you get ultimate target. I think Justice Lee put it well when he talked about a literal direct confrontation. So that versus an ultimate objective. I don't understand that bifurcation. I don't even understand why you couldn't have both.
I guess you could, but I think that's harder with the statute, the way it's written, where it talks about being directed at a specific person, and then all of the other parts of the statute which talk about communications through third persons, communications through others.
Well, those are just other avenues available, and other ways you could violate it. But I don't understand how if someone comes to me, looks me in the eye, flips the bird at me, and tells me to F off. I don't understand how that hasn't been directed at me, at least in a literal sense.
No, I think that it's been directed to you in a literal sense. I agree with you there. I think just within the context of the act, my interpretation is that the act is looking at the ultimate target. But yes, I would agree with you in a literal sense. Of course, it's directed at you because you're the person who's seeing it.
Okay.
But I also think that when we look at that, we also have to look at the interpretation the petitioner put on it before the district court, and the interpretation they espoused to the district court was not of there are two ways it can happen. One is direct, and it can happen to two people. You can have two targets at the same time. What they said was every single act that we identify, whether it's the signs, whether it's the communications with other employees, or the communications with Ragsdale, they're all directed to one ultimate source, and that was Ragsdale. And that distinction that you raised today was not one that was brought in front of the district court.
Thank you.
So accepting that argument and it seems that you're right, the district court rejected that argument from Ragsdale that everything that happened to any of the employees or customers was to get at her. So the district court said, no, he's just protesting ECA. But the incidents where he literally swore at or flipped off Ragsdale, don't those still survive as a course of conduct directed at her, even if you don't accept the argument that everything at everyone else was meant to get at her?
I think that might be correct, but this is an instance where the plaintiff didn't really make that argument. They didn't really, if you look at their closing argument, they did not point to each incident and say, here's how many incidents happened. Because, in fact, the court could have looked at it and viewed it there as being only one incident. And the reason why I say that is if you looked at the totality of the evidence, we have Ragsdale's claims that there were multiple incidents, but then we have her inability when she points to the records of all of these incidents, which include her incidents, she says, where none of them identify communications between Fishler and Ragsdale. And the only one that Fishler testified to was one incident where I guess he cursed at her and then she stopped and she cursed back at him. So those issues were never squarely addressed or brought before the court or argued before the court as a separate basis.
So you're saying in the evidence there are not multiple times when Fishler from his driveway flipped off or mouthed profanities at Ragsdale as she came to or from work?
I think there's conflicting evidence, and I think viewed in the light most favorable to the district court's ruling, that you'd have to look at it and say the judge could reasonably have looked at it and decided that there was only one incident or there was not a course of conduct.
It sounds to me like what you're suggesting is the plaintiff sort of took an all or nothing strategy and said to the district judge, consider anything and everything that was ever directed at anyone at ECA and treat it as if it were directed at Miss Ragsdale and treat that as the course of conduct. And that because the judge rejected that theory, it would be improper for us on appeal to sort of parse it and just look at individual acts directly directed at Miss Ragsdale. Am I getting that right?
Yes, that's exactly correct.
I'll ask this during rebuttal time too, but I want to make sure I understand this argument. One way of phrasing it is, when he was doing this to anyone, he was trying to get at me. The other way of arguing it would be he didn't like this business. He didn't want ECA being there. He took it out on all of us. He did it to Ragsdale. And when he did it to the employees and to the teenage girls who Ragsdale believed were vulnerable and needed help, when he did it to them, it was more upsetting to her than when he did it to her directly. That was more upsetting when she would find out he just did it to a vulnerable teenage girl who's coming to this place of business for healing and comfort. That was even more upsetting. Was that argument ever made, or was it the first, that he's just trying to get to me and I think it's almost like a parent. If you were trying to get at a parent and disturb them, if you did something to their child, it would be even more upsetting to them.
Right. But
what are the contours of this argument?
I guess what I'd say it's the first, but even the second argument that you're making is really a view of the first, because under that second argument, he is cursing at the teenage girls in order to get at Miss Ragsdale, because that will upset her more than any action he could take directly towards her. Does that sort of answer the question?
Was that the argument that was made, or was it more the first one?
It was the first one. It wasn't that he's doing this because he knows it'll hurt her more. It was that he's doing everything because it's all directed at her ultimately.
And that's what the court rejected.
Exactly.
Okay.
It seems like, that would make it acceptable to harass an ex-wife's girlfriend, and a defense to a stalking charge by the ex-wife's girlfriend would be, this is just my way of getting at the wife. And she's not here before us. She's not seeking a stalking injunction.
I think that doesn't seem to me make sense, and I think I agree with you there that if he's actually harassing this person, you might be right. But I think that argument wasn't raised in the district court.
It seems like what the district court was really zeroing in on was that this was sort of indiscriminate, that this wasn't directed at any particular person. It was more like standing outside a business and cursing at everyone who came and went, employees, owners, customers, clients. Is that what makes the difference here in your mind, is that it was indiscriminate?
Yeah.
And didn't zero in on any particular person? I mean, because I think you would concede, wouldn't you, that if he had zeroed in on, let's say, 3 people, Ragsdale, maybe her partner, someone else, the manager who worked there, and had taken additional steps, perhaps following them, perhaps confronting them, things like that. It's not that you can't stalk multiple people, right? It's that here it was so indiscriminate, it wasn't directed at anybody. Is that your argument?
Yes, yes, exactly. That here he wasn't zeroing in on particular individuals. This is no different, I guess, in a certain sense, than someone outside of an abortion clinic who says insulting things, calls someone a murderer, whoever walks in that door or walks out the door. And they're not directing it at a particular individual, they're directing at everyone. Or more so probably at the abortion clinic.
Well, it is not wholly indiscriminate in the sense that it's limited to those who he perceives to be employed
Correct.
by EDA, right?
Correct.
So he lets the public go. It's a broader class, but it's targeted at those who are employed by EDA. So
Right. It's targeted.
you could do three versus 5 versus 10. I'm not sure what that the consequence should be that would flow from that distinction.
I guess the distinction is one of whether you're generalizing it to everyone within a certain class, or whether you're or localizing it against a certain particular members of the class. And that might be a distinction that the court could look at.
Although it seems like this is part of the directive that you have to look at the circumstances, the surrounding circumstances. So if you had a large business and a person was standing out on the sidewalk, yelling at the building, and at any time people are streaming in and out of the doors, and you've got lots of people, and so he's really not interacting one-on-one with anyone. It's just one person out there screaming, and as all of you stream in and out, you all hear this guy. Here you have a residential area. You have a house next door to another house, and I don't know the number of people going in and out, but it doesn't sound like there are, multiple people streaming in and out. It sounds like one at a time people arrived, would go through the front door of a house next door and get yelled at by the guy in his driveway right next door, which those circumstances are different than many people coming out of a large building and no one really feels singled out by a person yelling on the street. It seems like those are different circumstances that have to be considered.
Sure. I mean, I think you can look at it that way, but I think also we'd have to look at the facts of this case where there were multiple people in vans that were going by where he was doing this as well. I think the testimony was there were about 40 trips a day going in and out of that commercial residence, which is what started the whole thing in the first place. So I guess that opens up as many questions as it answers by making that distinction.
That may be true. Thanks.
And then I would like, I'm out of time, so I don't know if the court wants to address the emotional distress issue or the political speech. I think they're both important and interesting issues, but I'm not sure if the court wants to spend that time.
Well, I think I would like to hear from you on the First Amendment, the First Amendment question. What precisely is your challenge, and walk me through your argument in that respect?
Well, I guess I'm not challenging the stalking statute itself or calling it unconstitutional or anything like that, because
not even as applied in this instance.
Well, in this instance, we won, so I wouldn't be able to say that it was unconstitutional as applied because I think it was applied correctly by the court.
Right. Well, yeah, you didn't win, but I'd still like you to.
Sure, I understand. I understand the question, though.
Yeah.
So what I am trying to say, though, is that the First Amendment trumps everything. The states can't adopt a law that abridges the First Amendment right. It can't. And I think that's shown by the model stalking statute, which actually says we didn't include a First Amendment exception there because the First Amendment trumps this. And we don't expect this to be used to suppress rights that are protected by the First Amendment. So at that point, what we just have to look at is conduct protected by the First Amendment or not? And there is conduct, I think quite easily we can show, that would violate the civil stalking statute, but that would still be protected by the First Amendment. And I think if we go to PETA, one thing that PETA does is it holds up signs with mutilated and decapitated animals that are very, very disturbing to look at. And someone could hang that up and put that outside, a business of any sort, and people could see that, and it could cause severe emotional distress, having to see that every day, mental suffering, seeing that every day. But that doesn't change the fact that this is political speech, it's protected, and the people who are exposed to that couldn't get a stalking injunction or shouldn't be able to get a stalking injunction, because I think that would be an instance of unconstitutional as applied. If there was a stalking injunction issued to stop free speech protected political speech because it caused severe mental distress.
Okay, so is the argument then that recognizing that you won, but we need to make a determination as to whether the court below was correct in concluding that this was constitutionally protected behavior.
Right.
Does it rest completely on the political aspect of it, that everything Mr. Ragsdale did had a political objective? It was outside the scope of the stalking statute, and to apply the stalking statute to this kind of political speech would make it unconstitutional as applied.
Let me clarify that a little bit. I think there are two analyses that the court has to undergo. The first is, can the stalking statute be allowed to prohibit or penalize or stop political speech or free speech that's protected by the First Amendment? I think that's the first question. The second question the court has to undergo is the particular speech at issue protected by the First Amendment, or does it fall within an exception to the First Amendment? So I think there's a two-part inquiry, right? The court has to decide, first of all, what's the interaction between the First Amendment and the stalking statute. And I don't think the court can find that the stalking statute can stop protected free speech. I think that would be a difficult explanation to generate. But then I think the second question has to be, well, is this protected free speech? Because there are exceptions to free speech. And I would say that the majority of instances where the stalking statute is applied is to speech and conduct that's not protected by the First Amendment, under the fighting words or the true threat. Because that is really what the majority of stalking is. It's true threats. It is threatening behavior, and threatening, I think, encompasses the sort of, conduct is meant to hurt or assault, or that's the sole intent of it. But I don't think that if conduct falls within protected free speech, that's not within an exception, it can be prohibited under the stalking statute.
So there is a recognized exception for conduct integral to a criminal act. Now, this is a bit circular here because stalking statute makes certain conduct criminal. So how do we sort through that analysis?
I think that the criminal conduct is not referring to sort of these kind of situations. I think they're talking about people who are actually making conduct, soliciting, for instance, people to purchase illegal drugs on a website. I think that's the sort of criminal, that's complicit in a criminal activity, rather than speech that is, falls within the stalking statute.
It seems to me, though, that may be getting off course a little to look at different analyses like fighting words or words that are sort of in service to criminal behavior. Isn't it just once words are used as stalking, once what you're doing meets the definition of stalking, stalking is not protected. You need to make your point in a different way. You can't do it through directing language at a person in a way, through repeatedly in a way that causes them emotional distress or fear for their safety. So stalking itself is conduct that you can't do.
Well, I think I disagree there, because I think fear for safety, again, obviously that falls within the true threat exception. So I think that right there, once we get to fear for safety, we fall within an exception, and we don't even have to, at that point, the stalking statute is applicable. I think the slippery slope that has to be addressed is the emotional distress, because there's plenty of speech protected by the First Amendment that can cause emotional distress. And that's where the court either has to, there has to be, I guess, a double-fold inquiry, right? The first is, what sort of emotional distress would trump the First Amendment, would say that this conduct is no longer protected. The second has to be, well, even if it just causes severe emotional distress, is that sufficient to say, well, now it's no longer protected by the First Amendment, it can be banned by the stalking statute?
Well, so take this example. So neo-Nazi parades, they can parade down Main Street, and that might be emotionally upsetting to people, but it's not repeated conduct directed at a specific person. If 3 members of the KKK decided they wanted to repeatedly go in front of a person's house and protest in front of their house, or follow a person around and yell names at them, they probably wouldn't be able to do that once it got to the level of stalking directed at a specific person.
Right. But there,
it still has to meet those requirements to differentiate from just things that you might do not directed at anyone that makes everybody feel emotionally distressed.
well, I guess though the examples you give, I would start saying that those fall within true threats or fighting words. I mean, if 3 neo-Nazis were outside of my house protesting, I think I would have a legitimate fear for my safety. That would be where I would come in on something like that, or true threat. I think
What if you take your example, your PETA example earlier, and instead of just standing outside a meatpacking plant holding up these graphic images, instead they zeroed in on the manager of the meatpacking plant, started following her to her home, holding up these signs where her children could see them, where she could see them. It isn't at some point, even though it's political speech, if it rises to the level of stalking, that's not going to be protected.
right, but again, the example you gave sounds to me like a true threat. I mean, this person is following me around with a sign. That's threatening.
Say it's not. Say they could feel completely safe, but it's enormously emotionally disturbing.
Right, but I guess again, we look at it objectively. It wouldn't be what they felt. It would be what an objective observer observed on those sort of things. And I think an objective observer in those circumstances.
So let me change the hypothetical. This person has police presence, police protection. So every time this person stands outside their house holding up these signs, there's police officers there. So there's no real threat of safety. Could that still rise to the level of stalking? Because and I guess what I'm trying to focus in on is, does the First Amendment protection at some point tie into that first element of having to be a course of conduct directed at a specific person?
I think it does, but I think at the point where that intersection is where it falls within an exception to the first, a recognized Supreme Court exception to the First Amendment. And I guess the counterexample I'll give you is someone who hates the president, who stands outside his residence, the White House, and every time the president's motorcade comes in, he singles out the president and he says a curse, or I hate you, or whatever. And I'm sure that the president would not take that well. He would find that emotionally distressing, because he finds a lot of criticism, at least press says he finds it very, he's very sensitive to it. So there, I think we're hitting emotional distress, but we would say that that's protected political speech. So I would look at it as being something where we'd still, even though we could go within the stalking statute, we would first analyze it within traditional First Amendment exceptions, and at that point, determine whether it is something that falls in the stalking statute or not.
Okay, thank you very much, Mr. Nadeson.
Thank you.
We'll now turn back to Mr. Dunkelberger.
Yes, thank you. Just to kind of go first to what was and wasn't argued or preserved at the district court, I think it is important to just direct a couple of record sites here. If you look at the record 267 and then page 270, that's my closing arguments to the district court. And I mean, I say Mr. Fishler is engaged in just about every sort of private communication to and about, directly or indirectly, Miss Ragsdale. In the beginning, it was the signs, and then I kind of go through what the conduct is. It's true, I think what Justice Lee said was true, to be fair and candid with the court, that we didn't win on indirect stalking. But it was
if I could jump in there, if you don't mind, if I could just jump in there. I mean, is Mr. Nadeson right that you kind of took an all or nothing strategy and you just lost? I mean, you tried to just ask the district judge to lump everything together and treat it as if every single thing that's done to anybody associated with ECA is really ultimately directed at your client, and you lost on that. And so and if that is what happened, how do we sort that out?
Yeah, so the Utah Court of Appeals has an interesting case, Carson v. Barnes, and it kind of resolves this philosophical question. Okay, if I can't show a course of conduct, and as one of my conducts, make a case for indirect stalking because it wasn't directed at me, it was maybe directed at the other person, can I nevertheless, for a Baird analysis, what became a Baird analysis, look at that as part of the course of conduct that would make me fear? So in Barnes, the first thing that the fellow did was point a gun, not at the petitioner, but at somebody who knew the petitioner. Okay. And then there was, I think, driving by and honking was the course of conduct, right? And the court looks at that, didn't count the pointing the gun as part of the course of conduct, but for the first prong, that is, was it directed at? Because it wasn't indirect stalking based on pointing the gun at the person, but it nevertheless went into the course of conduct for the purpose of determining whether a person would suffer emotional distress. And that's the same here. And that's exactly what we said. It's like, look, there were a number of reasons that she testified that she felt subjectively and that a reasonable person would objectively be fearful here. It's a person who they've never had a positive interaction. There is evidence at R105 that he sits in his car and waits for them to walk by. I mean, this was all, part of the evidentiary record, part of that course of conduct. So in one sense, we can separate those buckets of conduct for the purpose of meeting that course of conduct element. But then it is appropriate to ask the court to consider overall, what is happening. And Mr. Nadison asks the court to do the exact same thing with respect to the content of the speech. We think that first prong is essentially content neutral, but
I'm not sure if I'm following this. I mean, the statute says course of conduct, acts in which the actor follows, monitors, observes, et cetera, communicates to or about a person, and acts directed at or toward. So, I mean, and doesn't it have to be those same acts that would cause a reasonable person to suffer significant emotional distress?
Well, in that case, yes, except that.
That's right. I got lost in what you were saying a minute ago. You're saying even if at the first stage you got to separate those out, when you evaluate the ultimate effect on the plaintiff, you get to consider all the things, even those that weren't directed at her. I lost you.
Yeah, I must not have been very clear. So
maybe I just disagree with you. Maybe you can tell me what's wrong with what I just said. I mean, don't you look at the same acts at both stages?
Not necessarily under Baird, because Baird says all the attendant circumstances can be used to weigh whether that course of conduct, whatever the court credits as the course of conduct, would cause the person, a reasonable person, to suffer emotional distress. So yes, in the sense that I don't get to count those as part of this first element to meet the course of conduct. It just becomes an attendant circumstance. Just like, by the way, the political nature of it, or whether it's roses or a horse head or whatever it is, the actual content of the conduct or the speech is part of, it's not irrelevant to the Baird analysis because it's part of the attendant circumstances, just like any other instances where somebody did something else to somebody I know or as part of this overall course or other things. It just becomes, at that level, another reason why or why not somebody should, a reasonable person in that circumstance would experience fear. So I think I'm hopefully kind of saying that clearly. It's that, yes, you would, of course, just evaluate whether there is stalking based on the course of conduct that you credit as a matter of fact. But if you have found, for example, he said F you to everybody else at the house and routinely did that. Every time he saw someone else coming and going, he said F you to them too. But it just wasn't directed at her, so you don't count it for that first element, but it's undisputed that he does it to everybody. She says in the finding of fact that you do it to everybody. It becomes a fact that you can consider as part of the Baird analysis. And it does become important, and it was one of the deciding factors in Carson v. Barnes. So I'm out of time with respect to that.
Your mic Judge Hagan.
Thank you. But there were at least 2 acts directed at her. Let's take the situation where we just have someone standing outside a business yelling at every customer, every employee, everyone who comes and goes. As long as one of those people was subjected to that twice, is that going to be stalking for each and every person who encounters this person who's doing profane hand gestures and words 2 or more times?
It can. The question is, under Baird, is that going to meet with all the attendant circumstances that threshold, that second element? It's certainly a course of conduct if it's communicating directly to the person. And again, he's conceded, and I think very candidly and importantly, that there's no other way to interpret that piece of the statute. If you and I are alone on the street, my subjective motivation or intent, in fact, that kind of goes to the stalking statutes itself. So 4B under the stalking statute says that it doesn't matter, or it's not a defense that you did not intend to cause that person emotional distress. Well, that almost kind of would be the sort of intent element that they're talking about, right? That's the ultimate target argument almost that they're making, which is that I'm looking at you and I'm undisputedly talking just to you because we're alone. You're a specific person and I'm directing my words to you, but in my mind, I'm actually just trying to get at a beef. Every time we exchange kids, I'm telling my ex-intimate partner that to F off or calling him or her a name. But in my mind, I'm just really protesting the unfair child support guidelines under the Utah Code, right? Open season on that. And Mr. Nadasan would say, oh, no, there's not, because of course, come on, look at the context. Is it a usual? Is it an unusual stalking case? And the district court sort of bought off on that. Oh, in that case, it's a relationship. Everybody knows what we're going on. But isn't that a factual determination at the second step, right? We don't say, oh, because they're ex-intimates and he's just protesting the child support guidelines, that's not part of the course of conduct. Or that can never be.
Let me give you one other hypothetical. Sorry, we're hitting you with so many. There's a person who really hates Americans, and he's stationed himself in front of the White House, and every American or person he perceives to be an American who walks by, he makes gestures and says profanities to. So under your argument, if one of those people happened to walk by twice, so they were twice subjected to this, then this would be a course of conduct directed at that person.
If it is where, as we have here, undisputedly, I am directing it towards you specifically.
Well, let's say,
in that case, it sounds like it's
one at a time. People walk by one at a time, and every person, he makes eye contact with them, flips them off, and says a profanity. So if that happens to one individual more than once, that's going to be a course of conduct directed at that individual?
Yes, and Baird makes that clear. Okay, again, that it's not the content of the communication that defines whether it's in the course of conduct. The statute does that. You've got to run that then through that second step and consider the attendant circumstances. Is that a person who goes by every day? Has this been happening for 3 years? Is it a 60-year-old man on one hand and a 60-something and a 40-something woman on the other hand? Are there kids who have been traumatized in the house next door? Is it to the coworkers as well? Does it seem a little bit obsessive? All of these things that are part of the attendant circumstances has to be considered. To just say at a threshold level, oh no, he just hates Americans. So that speech that's directed at America hate can never be stalking under our statute. It completely eviscerates important parts of that stalking statute. And that goes to Mr. Nadasan's point on that as well. It's not, she didn't say that he wasn't directing it at anyone. The findings specifically say that he was directing it at everyone. Now, I mean, maybe that's too cute, the difference between anyone and everyone, but I think it does matter because she said here, everybody is targeted. So if everybody is targeted, then by her own findings, Miss Ragsdale, and she says, including Miss Ragsdale, done with that first element, let's get on to a fact finding about the second
one. Okay, well, thank you, Mr. Dunkelberger,
Thank you.
Mr. Natterson. We appreciate very much your arguments, and we'll take this matter
I
under
actually have
advisement.
to cross reply because there's actually a cross appeal.
Oh, I apologize. Yes, on the attorney fees.
Yes, I never got to get that. That's why I saved this time, because I suspected we wouldn't get to it in my mail.
Yeah, please.
So this is actually a really important issue for the court to weigh in, because there is actually no appellate guidance on how to determine when attorney's fees are appropriate. Specifically, what we know is that under the statute, the express language of the statute, anyone can get attorney's fees, including a non-prevailing party. The Court of Appeals has weighed in, and their guidance was simply that this is not the bad faith statute. You don't have to show bad faith or total lack of merit. The district court looked at it and sort of agreed that this was weighing of the equities, but didn't also conceded that there was really little to no guidance on how the court should weigh those equities or make a determination. And then the determination was made by saying, well, this is a complicated case. There's been no allegations or no claim by Mr. Fishler that there was bad faith. He hasn't shown that this lacked all merit, so therefore I'm going to deny it. But that's the very standard that doesn't apply. What we wanted the court to consider, and what we raised before her, was the motivations. Was this a commercial motivation? Was it an attempt to squelch a protest against a commercial business? Who was paying for the attorney's fees? Was it in this case, it was ECA who was paying the attorney's fees. We asked to look at the relative merits. So how much did the petitioner actually establish in terms of the merits of the case? I think who the prevailing party is obviously a factor that should be looked at as well. And then we looked at we wanted the court to look at the general policy issue that's raised by attorney's fees here, where in this case, I think given the unique nature of this, it would be easy if no attorney's fees are involved for commercial enterprises, for instance, the company that's being protested by PETA, to bring a stalking injunction and make the same sort of claims that we're hearing today, which is your course of conduct is affecting everyone, and therefore we think it's got to stop, and we want a really large injunction that prevents you from, yes.
Can I just ask you the question at this level? I like your argument that there needs to be some sort of standards and there needs to be some guidance given. But what's your best argument that somebody in Mr. Fishler's position, right, where the district court found that he engaged in a lot of the conduct that was complained of, should be entitled to get his attorney's fees? So, I mean, leaving aside just the general questions, in this case, what's your best argument that your client should be able to recover his fees from somebody that your client is, the court found has been yelling and screaming at the people who go to her business and
I'm going to disagree with you,
saying things to adolescent women.
Well, I'm going to disagree with you right there in terms of the yelling and screaming, because that was not
fair enough. He may not have raised his voice, but certainly he was cursing at them. That's in the court's record, isn't it?
Sure, he was cursing. He was mouthing the curse. He wasn't yelling them, certainly.
Yeah, and extending middle fingers and doing it to people who were minors. Is that correct?
Correct. I don't know if there's testimony that he's doing to minors or not, so I don't want to answer that one way or the other.
And I don't want to mischaracterize the record, but even in the most generous reading of the record to your client, give me your best argument that in this instance the equities weigh in favor of allowing him to recover his attorney's fees.
Sure. So the main argument that I would put is one of the commercial interests involved, which is this isn't the evidence doesn't show that this was a case where there was an imminent fear of harm or there was severe emotional distress. And the reason why I say that is because this happened for 4 years before anything was done. And I think just the way this appeal was practiced and the way the litigation was brought shows that there is no real severe emotional distress, because we have a year between the evidentiary hearing before an appeal is filed. We have no emergency orders. We have no interlocutory orders. We have nothing showing that's the case. We have multiple letters during that 4 years, 2 letters from the business to Mr. Fishler saying you're interfering with our business. Your conduct is interfering with our business. Not that you're stalking anyone, not that you're causing severe emotional distress. You are interfering with our business, with our profits. We have the ECA hiring the attorneys to prosecute this and paying for the attorney costs. We have, as a result, we have a situation where it's essentially a commercial entity that is paying for stalking injunction, and the stalking injunction is very broad. It doesn't just talk about communications to Miss Ragsdale. It talks to communications to anyone associated with ECA. A ban on that is paid for by the company in order to protect its interests. And I think that is the main issue that has to be looked at by the court. So it's not just what is the conduct? He was cursing at underage kids, so he shouldn't be receive attorney's fees. That's not how the court should look at it. The court should look at it from the view of what was actually alleged as the stalking behavior. Sorry.
I was a little confused by your argument that you thought we should review this as a matter of law. There's permissive language in the statute about the court may award attorney's fees. How can that be anything other than an abuse of discretion review standard?
Well, that's where I was confused as well, I would say, by that language, because the court has in other instances said that when it's looking at attorney's fees that are awardable by statute, it looks at it as a matter of law. I think that the court has to sort of balance how that plays out, because there are other statutes where the permissive is used and the court has examined it from a correctness of law issue. So based on that, I think it has to be a correctness of law issue. But I think also within this case, there's a difference between the normal abuse of discretion case and this case, which is the judge who made the determination on attorney's fees was basing it off the same transcript that's before the court here. It was not the judge who decided the case. So we didn't have the real issue that's usually raised for deference in an abuse of discretion case, which is the judge was there, she saw the trial, she could evaluate credibility, etc. That's not the case in this case. Sorry, Justice Duran, I can't hear you here.
Thank you. I thank you for your argument. We'll turn at this point to Mr. Dunkelberger.
Thank you.
Yes, just very briefly, thank you. So with respect to this question of what the district court did, I think we just have to stick really close to the district court's rulings and why it addressed the specific issues that it addressed. And I think that the court very deftly handled this question of merit and bad faith. She specifically noted that it wouldn't require, it didn't seem under the statute, a showing that it lacked all merit or was in bad faith. But if you look at the briefs leading up to the attorney's fees hearing and the questions really raised by the respondent here, Mr. Fishler, he only raised essentially two issues. They fall under merit and intent or bad faith. So this idea that, well, she did it not to vindicate her personal interests, but those of her business, that's a bad faith motive, right? An abusive process would be a bad faith motive. And so that's why you see the reasoning sort of focus on those two things. Well, I don't find those two things. It seems closer. There was a discussion by the court originally that this was rude and abhorrent conduct. There are some interesting constitutional questions and statutory interpretation questions that we've been discussing. It didn't lack all merit. And then in terms of bad faith, it just didn't credit that was the motivation behind this. And indeed it wasn't. And just to take a little bit of exception to Mr. Nadasan's view of the timeline. I mean, again, and it's kind of a theme here, but two things can be true at once. Something can harm a business, and also after 4 years, really start to cause fear of safety or emotional distress for the person who undisputedly owns the business. And so, again, it was for the district court to decide, well, what do I do with that? What do I do with all of that? The letter that I have originally from the business, and then the passage of time and other things. And at the end, did not, I guess, credit or did not find, as they hoped that she would, that there was a bad faith motive. And then, of course, between the time of Judge Bernard's Goodman ruling originally, and the appeal. I mean, we have to wait obviously for a final order, and that includes attorney's fees. So the attorney's fees litigation itself did go on for quite a while. But as to the timing of the appeal, I mean, we applied or we appealed timely as soon as we had a final order to do so. So again, that was for the district court to decide. She definitely did that as her ruling evidences, and with that, we'd ask that part of the ruling to be affirmed.
Thank you, Mr. Dunkelberger. Mr. Nadeson?
I'm just going to address one issue that was raised by Mr. Dunkelberger, which is the claim that the judge made a determination of those issues under the umbrella of bad faith. But that's not what the judge actually said. The judge actually said there's been no allegations by Mr. Fishler of bad faith at all. So she did not address those arguments that I just raised, in which Mr. Dunkelberger lumped as being bad faith. Those were not addressed by the court. Those were not examined. At least there's no evidence from either the oral ruling that the court ever considered those, and that may very well be because the court did not have a lot of guidance on what standards it should have looked at in making the equities determination.
Thank you, Mr. Nadeson, and thank you to you as well, Mr. Dunkelberger. We do appreciate your arguments, and we'll take this matter under advisement. So counsel is